The court is going to find you guilty. There's to be no unsupervised contact with minors. With regards to punishment, state, what are you requesting?
Your Honor, we're asking for the 10 years in prison.
Defense, what are you requesting?
Judge, I asked that he be sent, continued on probation and sent to ISF for a period of time to get his thoughts together.
The court is going to find you guilty. The court will sentence you.
All right, everyone, this case is nothing short of extraordinary. We're looking at a defendant who is about to learn whether he will leave the courtroom on probation or face the full weight of a potential 10-year prison sentence. The charges stem from a serious accident, one that left his own passenger significantly injured. Rather than remain at the scene and render aid, he fled. That single decision has now placed him at the center of a felony prosecution. Leaving the scene of an injury crash is not a minor infraction. It is a criminal offense that courts treat with considerable gravity. The presiding judge today appears focused, measured, and in no mood for theatrics. This is not a proceeding where sympathy or excuses are likely to outweigh the facts. The law is clear and accountability is paramount, especially when injuries are involved. So the question remains, will he receive a second chance in the form of probation, or is this the moment that permanently alters the course of his life? If you follow compelling courtroom proceedings and in-depth legal breakdowns, be sure to stay engaged. Now, let's take a closer look at how this case began.
You're charged with failure to stop and render aid, serious bodily injury. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
So you have a car accident, and your go-to is to leave. Why would you leave a car accident?
Everybody had left, and I just left myself.
Well, no, everybody didn't leave because there were two people remaining in the car, trapped, and somebody had to help them out. So why would you leave injured people behind in the vehicle?
I was one of those people injured in the car. And then I got out. They held me out, and then I walked home.
Okay, this is not where he's going to pretend he wasn't driving, is it?
We're pleading no contest, Your Honor.
Okay. So again, why would you leave someone behind in a vehicle that's injured?
You got out. Did you go to you're sitting in the curb and speak with you?
No.
Okay.
No. Did you call for help for anyone? Why not?
Just being ignorant.
You see, let me just tell you what I know about life from my time on the plane. And I think I can say this because I have more of my life behind me than in front of me.
Yes.
Is that big things somehow ends up snowballing for young people into bigger things. Number one, there shouldn't have been any speeding. Number two, nobody should have taken any drinks and driven. And number three, if there's an accident, you call somebody. If you would have stayed and helped, if you would have called somebody, guess what? We wouldn't be here for a failure to stop and render aid. So how are you getting around town without driving?
I take the bus. I'll walk if I have to. I have a daughter that I have to support. So
How old is your daughter?
she just turned 1, March 13th.
Are you and the mother together or no?
Sort of. We talk. We're not married, so we don't live together.
How far did you go in school?
I stopped at 11th grade.
Why?
Just struggling with my family.
What does that mean?
Like, I have to take care of my little brothers sometimes, most of the time, because my mom is just not healthy. So I'm really like their dad, and I'm always there to help them out and stuff like that. So
What do you mean she's not helping? Where is she?
she lives with her mom. Yeah, she lives with my grandmother.
And so how old is your little brother?
My little brother, he's 13.
So where is your little brother living?
He lives with me with my uncle.
So was Child Protective Services involved?
Yeah, they're talking to my mother right now. So there's a case, I think, that's open with my mother.
So what are you planning on doing for the rest of your life? Are you going to be working at Bohannon's, or are you doing something else?
No, I was gonna work at Bohannon's for a little bit until I get my own apartment, and then get my GED and eventually try to join into the military with my friend.
The defendant who caused this crash is now standing before the court claiming he wants to turn his life around. He says he plans to join the military, essentially presenting himself as someone ready to become a productive citizen, even a hero. It's an ambitious vision for future. But the court cannot ignore the past. Specifically, the fact that after the collision, he left his injured passengers behind. That decision alone speaks volumes. Abandoning seriously injured individuals at the scene of a crash is not a lapse in judgment. It is a grave failure of responsibility. The justice system is not built on hopeful promises. It is built on accountability. A felony hit and run involving injuries is an extremely serious offense, one that can carry a sentence of up to 10 years in prison. And from the judge's expression, it appears this is far from the first time they have heard a last-minute plan for redemption offered in mitigation. So the real question becomes, should a sudden declaration of life reform meaningfully impact sentencing? The defendant has also pointed to a difficult childhood, suggesting that his upbringing played a role in his choices. While personal history can provide context, it does not eliminate responsibility. Many individuals endure challenging backgrounds without resorting to conduct that endangers others. A troubled past may help explain behavior, but it does not excuse it, and it certainly does not serve as a get-out-of-jail-free card when innocent lives have been placed at risk. Is the court persuaded by this narrative of transformation?
Well, I always tell people you can't keep saying you're gonna, because you're gonna going to wake up and 5 years of your life will have passed you by. You understand? Cats 1 and 2. Was there some sort of theft involved? Was there a reason for cats 1 and 2?
The case that was TIC was a burglary of a habitation, Judge.
All right. So here's the thing about burglary of habitations, right? I haven't been presented with any evidence, so I don't know what it says. But what I do know is that entering people's homes without their permission, it's going to end up resulting in one of two things for you. One, it's going to end up being a prison trip. And burglary of habitations, range of punishment is 2 to 20 years. Or either you're going to break into somebody's home and you're going to be shocked to find that they are at their home, and you may end up being shot or killed. And you know what people are going to say? It was justified. You're in somebody's home, you're not supposed to be. So I'm going to put down cats 1 and 2, but I can give you cats 1 and 2 course in 2 minutes. Don't take what does not belong to you, which people should have learned in preschool. And when you go to someone's home, only go if you're invited, and then when they ask you to leave, leave. Life is so simple, people make it so much difficult than it has to be. So cats 1 and 2. And the MRT, which is supposed to teach you right from wrong, which again, we should learn that in preschool, right? If everybody would treat others the way they would like to be treated, you would need the MRT course. So remember that as you're taking that course. I'm going to want him tested for levels. And those levels need to start going down. Do you understand?
Yes, Your Honor.
Okay.
All right. The court now transitions to one of the most pivotal moments of the hearing. The judge is bringing one of the crash victims into the Zoom session, and the atmosphere immediately shifts. What was already a serious proceeding is about to become even more intense. This young woman is living with permanent, life-altering injuries as a direct result of what happened. Her future has been irreversibly changed. Listening to her story is difficult because it forces everyone in the courtroom and everyone watching to confront the human cost of a single reckless decision. Take a moment to consider that reality. Imagine having your life permanently altered because someone chose to act carelessly. In an instant, everything can change: health, independence, plans, dreams. These are consequences that cannot simply be undone. In cases like this, the law treats victim impact statements with the utmost seriousness. They are not procedural formalities. They are a critical component of the sentencing process. Judges carefully weigh the physical, emotional, and financial toll suffered by victims. In many instances, victim impact testimony can significantly influence the court's final decision. So as we move forward, consider what you've seen so far. What are your thoughts on this case at this point? The next few moments are powerful. Let's listen closely to what she has to say.
Ms. Pettis has some words to say to you. I require that everyone treat everyone with respect, so just listen and internalize what I'm saying. You may proceed.
After everything, I don't think that you should be in prison or, but I did suffer injuries that are like for a lifetime. And I just want you to understand that because I did go through all of that, you do deserve to go through some kind of consequence. Did I cut off?
Yes, you did.
They keep calling me that, so I'm sorry. But yeah, that's all I have to say. But I do forgive you. Like, it happened. It's been a long time already, but I just didn't, I hope you just know where I'm coming from, James.
All right, thank you so much. Do you all need to speak with her?
I don't believe so. We have contact. We can talk to Ms. Pettis after this. Thank you, Ms. Pettis.
Thank you.
Thank you.
All right, probation will go over conditions with you.
All right, here's the situation. In the original hearing, the judge made a significant decision. Rather than imposing a potential 10-year prison sentence, he granted the defendant probation. Given the circumstances, that was not an unreasonable outcome. In fact, it could be viewed as a measured and restrained exercise of judicial discretion. The alternative was severe. Probation represented opportunity instead of incarceration, but this is where things take a sharp turn. Because in the next clip, the same defendant is back in court. And the reason? He outright refused to participate in the very probation that spared him from a decade behind bars. It raises an obvious question. How does someone squander the one opportunity designed to keep them out of prison? How do you disregard the exact conditions that were put in place to protect you from serious time? The judge, understandably, appears prepared to address this head-on, and the atmosphere in the courtroom shifts quickly. The patience extended during the first hearing is no longer guaranteed. To be clear, probation is not a dismissal of consequences. It is not leniency without responsibility. It is a structured second chance. It allows an individual to demonstrate accountability, compliance, and a willingness to reform without immediately resorting to incarceration. In this case, the initial decision seemed fair. The victim herself expressed forgiveness and showed notable restraint. That undoubtedly factored into the court's reasoning. Offering probation under those circumstances reflected balance, accountability paired with mercy. However, probation is conditional. It is a test of reliability and respect for the court's authority. Failing to comply is not a minor oversight. It is a direct violation of the court's trust. If I were in the judge's position and saw the same individual return, having ignored the conditions entirely, the frustration would be difficult to conceal. The court extended an alternative to prison, and instead of treating it as an opportunity, the defendant appears to have treated it as optional. Probation is not a free pass. It is a privilege, and when that privilege is disregarded, the original sentence remains on the table. In this case, that means the full 10 years the defendant worked so hard to avoid. So what was the strategy here? Was there one? Did he assume the court would overlook non-compliance? Did he believe the warning carried no weight? That is rarely how the system operates. Now, as we move into this next segment, the tension in the courtroom becomes unmistakable. The judge's demeanor suggests that patience has limits, and those limits may have just been reached. Let's take a closer look at this heated sentencing hearing, because it's clear this second appearance is going to unfold very differently from the first.
Are you the same James Madrone who was placed on deferred adjudication in 2021 CR 2437 for the offense of failure to stop and render aid serious bodily injury on March 21st, 2022 for a period of 10 years? Is that you?
Yes.
James Madrone did then and there fail to report to the supervision officer as directed for the months of January and December 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True, Your Honor.
State?
Your Honor, we waived the other violations alleged in the motion.
No objection.
All right. Mr. Madrone, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, I understand.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, Your Honor.
Court will find violation of condition number 4 true. Is there a proposed agreement?
It's not, Your Honor. We're going open. We are asking for the 10 years, Your Honor. I believe the defense might be heard on it.
All right. Defense, what are you requesting?
Judge, we're requesting that he be placed on probation, that he be given weekly UAs and intense supervision. Basically, Judge, this was a lot dealing with financial issues. He has 2 small children that he was responsible for, living with his grandmother at the time. He's now presently employed. I believe he has the resources now to continue taking drug testing and support his children. So I think basically, Judge, if we give him weekly UAs and ISF, and put him back, not ISF, but intense supervision, that he's able to complete the probation successfully. You have anything to add, James?
Yes, Your Honor.
All right. You want to raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
James Madrone.
All right, it says here that you didn't talk to the manager and you left when asked to stay in the lobby by the probation officer.
Your Honor, I was, my grandmother, thankful for her that she helped me with my burdens when I had to do these reports and everything, and she would have my kids in the car while I'll be reporting. So at that time, I really didn't have too much time to be there due to my being responsible for 2 children. So that was just that at that time. That was it.
Okay, that doesn't make sense to me. Your grandmother is helping you with your children.
Yes.
And how old are your children?
3 and 1.
All right, so she's helping you with the 3 and 1 year old. So you're telling me your grandmother drives you to see your probation officer,
Yes.
and then says, I can't wait.
Yes, Your Honor.
That doesn't make any sense to me.
It's just like I have real no support, really none. It's just me out there.
All right, so your grandmother is not supporting you.
Well, in a way she is.
In this case, the defendant claims he failed to report to the probation officer because he needed to pick up his children. At first glance, that explanation might seem understandable. However, his account quickly becomes inconsistent. He initially states that his grandmother was assisting him, only to later reverse course and insist that he has no support at all. That contradiction raises immediate concerns. When a defendant presents conflicting explanations within the same hearing, it inevitably undermines credibility. The court expects clarity and accountability, not shifting narratives. From an outside perspective, the story begins to feel pieced together, less like a coherent explanation and more like a last-minute attempt to justify noncompliance. And that is a serious issue, because probation is not a casual recommendation. It is a court-ordered directive. When a judge grants probation, it is often in place of incarceration, with a clear understanding that strict conditions must be followed. Failing to comply can carry significant consequences. Instead of offering a consistent and responsible explanation, the defendant appears to be presenting whatever justification he believes might resonate in the moment. That approach is unlikely to be persuasive. Judges are trained to assess credibility, and inconsistencies are often viewed as red flags. The question then becomes, is he simply overwhelmed and reacting out of panic? Or does he genuinely believe that these shifting explanations will serve as a solid legal defense? What are your thoughts? Does the story sound believable, or does it raise more questions than answers?
In a way.
All right, and then it says that they tried to have virtual meetings with you, and you kept rescheduling, and they allowed you to reschedule it and reschedule it and reschedule it.
Again, I had Financial burdens.
So you didn't have a cell phone?
No.
You couldn't get a ride by via bus?
Your Honor, my grandma lived in Leon Valley and she moved over there by Lackland Air Force Base, and I did not have reliable transportation.
Oh, no. I know for a fact that there's transportation by via for Lackland.
Oh.
And you know how I know there is that? Because one time I made a mistake and got on the Looper, which I believe is the 510, and it takes you all around the city. And I was like, wow, this is where the bases are.
Yes, but where I had to report was over there by 1604 in Bandera, which
Via.
yes, Your Honor. They canceled that bus route. I know it sounds like if I'm making it up or not, but yes, they did cancel that bus route for that reason. That drive was very, very extreme.
Did you pick up the phone, call probation, and say, hey, this
Yes,
is
Your
where
Honor.
I am? Okay.
Yes, sir.
All right. Any other questions?
Mr. Madrone, my name is Hank Wilkins. If I ask anything you don't understand, just let me know and I'll try and rephrase it, okay? Do you know the last time you reported?
The last time I reported was
This year?
yes.
It was this year? So would you just promise Len that probation thinks the last time you reported is November? Did you ever do the CATS depth course?
No.
Did you do the CATS 2 depth course?
No.
Did you do the moral recognition therapy?
No.
Did you do anything on probation?
I had parenting classes that were available online, which I did do, and it waived over my community service.
I'm sorry to interrupt. How can you do the parenting classes online,
They
but
were
you
for
can't
free.
report? No. But you can't report to probation online. Explain that to me.
I did report to probation online every time I had a Zoom meeting, and when it was in person, it was hard for me to be able to report due to my lack of transportation.
Do you remember telling probation in January of this year they're not going to do anything?
No.
You remember telling them, I know the judge will reinstate me?
No.
He presents himself in a manner that raises immediate concerns. From the outset, his demeanor appears inconsistent with someone confidently asserting their innocence. The body language, the noticeable pauses before answering, and the way he stumbles through his statements all suggest a level of discomfort that is difficult to ignore. It creates the impression that he may be distancing himself from words or actions he previously acknowledged. What stands out even more is his assertion that probation would serve no meaningful purpose. That claim is striking. Probation is not a trivial condition. It is often the final opportunity granted before significantly harsher consequences are imposed. In many cases, it represents the critical line between supervision in the community and a lengthy prison sentence. To dismiss it so casually demonstrates either a lack of understanding of the gravity of the situation or a troubling disregard for the court's authority. From a judicial perspective, a probation violation is not a minor administrative issue. It signals a failure to comply with the conditions set in place as an alternative to incarceration. Courts do not simply overlook such violations. When an individual breaches the terms of probation, the system is designed to respond decisively. Accountability is central to maintaining the integrity of the process. It is possible he believed the violation would be treated as insignificant, perhaps assuming the court would issue another warning or extend leniency. However, that assumption overlooks how the justice system operates. Probation is, in many respects, a second chance. When that opportunity is disregarded, the court must weigh whether continued leniency is appropriate. As we move forward, the focus now shifts to sentencing. The judge's response will likely reflect not only the violation itself, but also the defendant's attitude and credibility throughout the proceedings. This is a moment where consequences become tangible, and the court determines whether this was simply a lapse in judgment or a pattern that warrants a far more serious outcome.
Saying that when you pled to this offense, That's a third-degree felony, right? You're looking at up to 10 years in prison?
Yeah, I do understand. Yes, I understand.
And you knew that, and you still didn't do these conditions of probation, right? You didn't do the
No.
moral recognition therapy?
Not that I had faced financial burdens, so I did not have support from the mother of my children. She was attending school at the time, but now I have a reliable job. I have the means to prove to the court that I could be responsible in finishing my term with the probation.
Seems like the easiest thing to do would be to report, though. You didn't report it all this year, right?
No, because she said that she was going to file a motion to revoke, and I had said that, okay, that we have to do what we have to do. That's simple. That's what I had said in that response.
I'll pass the witness, John.
Nothing further, Your Honor.
All right. Probation. Was there any restitution for Elise Perez and Kimberly Soto? All right. So this is what the court is going to do. The court is going to find violation of condition number 4 true. The court is going to find you guilty. There's to be no unsupervised contact with minors. With regards to punishment, state, what are you requesting?
Your Honor, we're asking for the 10 years in prison. This is a third-degree felony. This is a SBI, Your Honor. Some other cases were taken into consideration of this plea. The defendant had opportunities to plea position. He didn't do much of anything on probation. I was trying to get some more information today. None of the answers are very satisfying for the judge. So we're asking for 10 years in prison.
Defense, what are you requesting?
Judge, I asked that he be sent, continued on probation and sent to ISF for a period of time to get his thoughts together. And be able to get out on the street and be a productive member of society and also a father for his 2 children.
All right. Oh, yes. You wanted to add something?
May I address the question?
Sure.
Yes, I would like to say that I would like to suggest no tolerant probation, where I may be supervising weekly UAs. I do not use drugs, and or an outpatient program, intense outpatient program that I can prove to the court where I can be responsible in completing my probation successfully.
Okay. All right. This is what the court is going to do. As previously stated, the court is finding violation of condition number 4 true. The court is going to find you guilty. The court will sentence you will sentence you to 8 years in the prison. There's to be no unsupervised contact with the minors. The court will give you credit for any time served, and the court will request the therapeutic community. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it, and did you sign it?
Yes.
All right. You do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Do you understand? All right. Good luck to you. We can go off the record. Here's the thing. I can't force them to place you in the therapeutic community. You'll have to request that. And then it's completely up to them whether or not they place you in the therapeutic community.
Your Honor, what was the consequence again?
Oh, you're going to prison for 8 years.
I'm going to prison for 8 years.
Yes.
And that's the done deal.
Yes.
Okay.
All right. Good luck to you. Okay.
Let me know in the comments what you think about that sentencing. 8 years is an incredibly long time. Just pause for a moment and think about where you were 8 years ago. For many of us, it feels like a completely different chapter of life. So distant that it's hard to even remember the details. That's why a sentence of that length really stands out. Do you believe he deserved the full 8 years? Personally, I'm not entirely convinced. Hear me out before jumping to conclusions. I absolutely believe he needs to serve time. Prison is warranted here. But 8 years feels substantial, especially considering the violations stem from missing probation. Perhaps something closer to 4 years might have felt more proportionate. That said, I'm not the one on the bench, and sentencing decisions involve factors we may not fully see. At the same time, I understand where the judge was coming from. Probation is already a second chance. It's an opportunity to demonstrate accountability and respect for the law. Instead, he disregarded that opportunity entirely, and we cannot overlook the fact that his actions harmed multiple people, seemingly without remorse. That is not minor misconduct. The justice system exists to protect victims and uphold accountability. When someone behaves as though they are above the law, especially after being granted leniency, there are consequences. In that sense, the court's decision sends a very clear message. Given the pattern of behavior, prison is likely where he needs to be, and his reaction at the end, it was striking. He appeared genuinely stunned when the judge imposed a full 8-year sentence. It raises the question, what was he expecting? Another warning? Another second chance? The seriousness of the situation seemed to fully register only once the sentence was announced. Watching that realization set in was a powerful moment. I'll wrap the video up here. If you enjoyed this breakdown and would like to see more content like this, be sure to like and subscribe. And again, I'm genuinely curious. Do you think the sentence was fair or was it excessive? Share your thoughts in the comments. Thank you so much for watching and take care.